Good morning, my colleagues, and to the people of Guam. The Committee of the Whole will remain at recess pending the arrival of my colleagues so we can ensure that we have quorum. Thank you. Committee of the Whole is called to order. My colleagues, before we begin, we will start first with the swearing in of Vanessa Valencia with the Office of Finance and Budget. Ma'am, if you please rise.
Please raise your right hand. Under penalty of perjury, you affirm that any and all information that you provide today, whether it be verbally, electronically, and in writing, be the truth, the whole truth, and nothing but the truth, so help you God. Mr. Chair, you're under oath. You may proceed.
Thank you, Sergeant Arms. My colleagues, we sent to you it's in your drive in reference to the information that was asked yesterday. And what we'll do is we'll take a maybe 5 to 10 minute recess so that hopefully it'll be sufficient time for you to review the document. And then we'll continue on where we left off. All right? We'll recess at this time. Committee of the Whole is called back to order. My colleagues, you've had some time to review the drive on the information provided. Unless the Attorney General has any statements to make in reference, if not, we will proceed. We are now going to our second round. My colleagues, we are on our second round, and we will begin with Senator Tello. Are you ready for the second round, ma'am? We're going to begin with you.
Thank you, Mr. Chair, and good morning to my colleagues, and thank you for being here again to the Attorney General's office, as well as OFB. Good morning. I have reading this document that was brought before us and looking over this 15-15-70 scenario, and it talks about the allocations going to certain accounts. It talks about the abatement account fund as well. Can you explain to me these different accounts and are required by the agreement of the award that it be placed in 3 different categories? It talks about allocation statute, statutory trust, and abatement. So can you explain that for me, please?
Ms. Taitano or Mr. Paris?
So the 15, 15, and 70 is actually the distribution of the proceeds. So no less than 70, I believe, has to go toward abatement programs.
And can you explain what the abatement, because it talks about, like in the California situation, they created an abatement fund, and it's basically to not have to avoid to pay taxes, if I'm not mistaken. It has something to do with taxes. In fact, any of these funds that are paid out to, like, say, victims or companies that provide services for rehabilitation, things like that, is
Yes.
this tax exempt from them reporting any kind of taxes on this funding as well? So we go to abatement first. I'm sorry, it's a 2-part question. So.
No, yeah, I understand your
Okay, thank you.
question, Senator Titaglia. I guess I'm not sure about the tax implication at this time. But if they are, like any other maybe funds that are provided to service providers, I don't believe those funds are taxed, so I imagine that this could be similarly applied, but I can't say for sure at this time.
Okay, we're not
But for
sure.
example, with the McKinsey settlement that we received, we did enter into agreements with service providers and would reimburse any expenditures that they made toward rehabilitation, abatement, or anything to help these clients be able to have a chance to be able to go back into the community successfully. So those funds weren't taxed on the provider. They were just provided, well, it's going to be on a reimbursement basis. So they would have to show that the funds, that they spent funds according to the terms of the settlement, and then we would reimburse them.
Okay.
So there were no tax implications, and I imagine the same would be applied in this situation. But
Yeah.
we would, of course, verify before we do anything with those funds. And we'll look at California, because I'm not really sure what you're referring to.
And can you explain the 15-15, what are those accounts for? And does this bill incorporate some of these concerns in the bill, like the makeup of 15-15-70?
So definitely the bill would have to follow those strictures provided in the settlement. So when looking at how to spend these funds, they would have to make sure that they use the funds for abatement purposes, and the settlements, which include exhibits identifying how these funds could be used for abatement purposes. Do you remember the 15-15 allocation?
Yes, so the 15-15, the second 15 is for states that have subdivisions. And so there is a designation for the 15% in that, and then the 15% for the state itself. In our case, it would be for the territory. And so the breakdown would be 15, 15, and then 70 solely for abatement purposes, which is what Ms. Titano was explaining.
Can you tell me what is spent, 15% going into the subdivision and then the 15 into the state? Is there like a discretionary, or is there a guideline on how to spend that?
The 15 to the subdivision, since we don't have subdivisions, I think we had asked whether that just rolls over into the other 15%. I think we're still getting clarification on that. Okay. And that has broader use, but it still has to be related to opioid and substance abuse. And also, can't be used to supplant existing money that's being provided to, for example, the Guam Behavioral Health for their existing programs. It would support them, but not supplant them.
Okay, so there's still a lot of unanswered questions that, as far as like the allocation or how to spend this funding. I'm sorry if you can hear me. Okay, so my last question on this is, the bill creates a council, and the council is put together, and if you look at the beginning of the bill, or beginning of this section, there's nothing in here that requires the council to follow these guidelines. Would you think it'd be pertinent to indicate that on section 221604 of the legislation on page 5, where it creates a council, the advisory council, there shall be an opioid recovery advisory council established to determine the allocation and expenditures of the fund. It might be just, overthinking it, but should it indicate that and shall follow the guidelines as stipulated by the spending of this fund?
I don't think that would be a problem, but I also point out that section above it actually lays out how these funds can be used.
Okay.
But if you feel more comfortable putting such a language, I don't think it hurts the bill.
Okay. Well, I was just thinking on your end, because you are a part of this advisory, but you're a non-voting.
Yes.
You're non-voting, so.
Yeah. So the legislation has us administering the funds, and and since we are part of the litigation, we would follow the settlement agreement, and and the section above it, which is section 221603, actually has language that we could only use the funds in accordance with any order of the court.
So then you're comfortable with this?
Yes.
Okay. Thank you, Mr. Chair, for the opportunity.
Thank you, Senator Tello. Senator Tony Ada, do you have any questions, sir?
No questions, Mr. Chair. Just like to thank the panel for being here to answer our inquiries. Thank you.
All right, thank you. Senator Brown, Senator Joanne Brown. Ma'am?
I don't have an extensive question, but I do want to ask, I know that you have to form the committee and put all that in place. What's the timeline that you're looking at doing that, so we can get a general idea of how, on an annual basis, maybe you might phase different parts of the program in as time goes on, and how you're going to expend the funds? Do you have an idea of when we can expect publicly to know exactly how, like for your first year and so forth, moving on, because it's over quite a number of years, how your committee that's being put together will prioritize, or, give us a general idea in the public of how over time the funds are going to be paid and what the bigger priorities are.
Thank you, Senator Brown. So as soon as this legislation is passed, I imagine that the committee would get together, because we anticipate distribution as soon as July. So it only makes sense that they meet as soon as possible to start planning out how these funds can be expended. I know the legislation has a reporting requirement, and it also requires us to post our reports on our website. I don't recall, it says annually, but with every government committee that meets, or board and commission, they usually post, their minutes. And so after any meeting on determining how best to spend these proceeds, following the parameters of the settlement agreement and the legislation, I'm sure that would be available soon thereafter. And we could work towards doing that.
No, I appreciate that, and I hope you advertise it just so that we know, obviously we have a growing issue of drug use on Guam, and we'd like to see, certainly we're very appreciative of the fact that these funds have become available. But again, I think it's just important we just know how that's being prioritized and determine how to be spent. Thank you very much. Thank you, Mr. Chairman, for the opportunity to ask the question.
Thank you, Senator Brown. Senator Shelton, do you have any questions? None. Senator Paris, do you have any questions, ma'am?
Yes, thank you, Mr. Chair, and good morning to the panel. Just want to maybe clarify, the last time we spoke, that the company Purdue Pharma is undergoing bankruptcy proceedings. And just if you can clarify if the money that is due for settlement, is that guaranteed? Is it already placed in an account? Or how is that going to be administered if the company is undergoing bankruptcy?
Mr. Perez will explain the Purdue bankruptcy, but once we receive the Purdue proceeds, it would follow the same setup as provided in this legislation. But as I said, Mr. Perez can explain the status of the bankruptcy case.
Thank you. So in the bankruptcy, like we said yesterday, there is an appeal in regards to the settlement agreement. Without getting too detailed, the way the Purdue bankruptcy, there's a reorganization happening in the company. Part of the proceeds is, there's a lot of different structures going on in the reorganization, but part of it is that there are certain profits that are going to be set aside for distribution to the states that are related to the opioid abatement. And that's why at least a firm number is not yet realized, only because of the reorganization that's happening for the bankruptcy. But without getting too technical as far as how the different restructurings happening for Purdue, that's just kind of the generalized system that's being set up, is that funds from the profits of this new company, which doesn't even have a name yet. I don't know if they're going to keep Purdue still, but whatever the new company is going to be, certain profits are going to be set aside for the new entity and for redistribution to all the states.
Okay, thank you for that response. So the other question I have is, does this settlement bar any further legal action?
That was a broad question, but further legal action related to opioids and their deceptive marketing and fraud. But of course, it doesn't necessarily cancel any other litigation that is unrelated to this.
All right, thank you. So maybe a question for Vanessa. So what is your understanding when we receive funds that are not general funds? Who has purview over that according to the laws of Guam? Is it appropriable, or does it have, how do we handle that? I know this discussion has come up before, but what is your understanding about funds such as this? Who has control over that if this bill were not to pass?
Thank you, Senator. To my understanding, OFB would not have to appropriate those funds. As for who's in charge of it, I don't have that information right now, but as soon as I do, I'll get back to you.
Thank you. Maybe this question can go towards Shannon or John. So what is your understanding of the laws of Guam if this law is not in place? Who has the authority to allocate this?
Yes, so currently under the Consumer Protection Act, and that's how this law, how we became involved in these lawsuits through our consumer division. It allows for the consumer division to seek appropriate remedies and administer those remedies. So similar to the McKinsey settlement, under that authority, we used it to follow the parameters of the settlement agreement and distribute the proceeds under that authority. I imagine that these proceeds would fall under the same authority, except for the fact that in the settlement, it asked that an advisory council be set up to basically oversee and manage the expense, or oversee, I should say, how these proceeds could be or should be spent. I haven't actually looked at the issue of whether these proceeds specifically would be considered revenue subject to legislative appropriation, but we do have authority under the consumer laws to potentially be able to administer these proceeds, again, under that law. I think some of the sample legislation has provided, I mean, not sample, but the other jurisdictions, it looks like they may have appropriated some of these funds, and I suppose that is the prerogative of the legislature, but you just have to keep in mind that everything is subject to the settlement agreement, and whether this body wants to be in charge of how these proceeds and whether we comply with the settlement, I guess is your discretion, but again, the advisory council is something that specifically is set up in the settlement agreements.
Thank you for that response. Okay, going back to the 151570, so it states 15 to the state and 15 to subdivisions. So Guam is, basically we don't have subdivisions.
That's
so
correct,
that would
Senator.
mean 30% goes to.
We're getting clarification on that. Yeah, and so we can't confirm at this time whether the 15 that would otherwise go to subdivisions gets rolled over to Guam. But we had asked early on about that, so we could provide, once we get that confirmation, we can definitely provide that to the legislature.
Because, that could be 30% goes to administration, which seems to be a lot, quite a bit.
Yeah, well, it's meant to be used for opioid-related programs and not just to be appropriated for general purposes.
Okay. All right, thank you. That's my questions. Thank you, Mr. Chair.
Thank you, Senator Barros. Senator Moylan, do you have any questions for the panel?
Thank you, Mr. Chairman. Just to try to remind me, we've had some really good questions coming around, and I just want to go back to the original bill, which is, as I read it, we're establishing an Opiate Prevention and Treatment Act, and it does two things. One is Opiate Recovery Trust Fund, that's one, and two is the Opiate Recovery Advisory Council, that's two. And this is all part of the requirement for the Settlement Act. That's all we're doing. I appreciate all this other information that you're providing to us, and it's very helpful and knowledgeable. But what this bill does is just those two items. If you can make sure I'm on the right track, please.
Yes, you're correct, Senator. Thank you for that.
Okay. Thank you, Mr. Chairman. Thank you to the panel.
Thank you, Senator Moylan. And to my colleagues, legislature is experiencing issues with the session email account. Please send your proposed amendments to clerks@guamlegislature.org. And as soon as we get the update, we'll advise you and that be resolved. Senator Duenas, do you have any questions, sir, to the panel?
Good morning, Mr. Chairman, and I don't have any questions, but I wanted to thank Ms. Taitano and Mr. Perez and the Office of Attorney General providing us the materials, and just put this on the record in terms of the research, because this was discussed on Tuesday. Under settlement spending on the opioid settlement tracker in the literature that was provided, I just think this is important to put on the record. Number 2 in a list of at least 5 guidelines is, and this would be a great template for when the council does convene, should this bill become law, use evidence to guide spending, direct funds to programs supported by evidence, remove policies that may block adoption of programs that work, build data collection capacity. I just think that was what Ms. Taitano was discussing the other day. And then also the investment in youth prevention, directing funds to evidence-based primary prevention, intervention programs. I think that's really key. So wanted to put that on the record and say thank you for providing this literature. And it looks like there's a lot of great guidelines to work with that have already been established, and that this settlement's being tracked as well nationally. So that's all I have, Mr. Chairman. I think this is a good bill, and it will provide proper structure. Jesus Masi.
Thank you, Senator Reyes. Senator Torres, do you have any questions, ma'am, for the panel? None? Thank you, ma'am. Senator Nelson, do you have any questions for the panel?
I'd like to yield my time to the speaker.
All right. Madam Speaker, you have 10 minutes.
Thank you, Mr.
All
Chair.
right.
I just want to note for the record, so we received from your office the links this morning. The Attorney General's office said they submitted some of this yesterday, some of it this morning. So we're scrambling to review, but what I want to ask is, overall, so the Attorney General in October in their letter told us that there are different ways to structure this. Of course, we're all in support of establishing a trust fund, absolutely. And an advisory board, absolutely. I think it's a great idea. I think the composition as set forth is good. I don't think it mirrors some of the other jurisdictions, but it's okay, it's debatable. But the other part that I think the biggest question for us as a legislature is control of the funds, right? Who controls the funds? So according to those here today, the Attorney General's representatives, this bill gives all our settlement funds into a trust fund, and it authorizes this advisory board to dictate how this money will be spent. This is a big departure from how tobacco settlement funds are handled. The tobacco settlement, in contrast, the legislature dictates percentages of where those funds will go to what types of programs, very similar, and yet it doesn't delegate that authority except to the Cancer Trust Fund Board for certain grants. So we put money aside for certain grants direct to providers, things like that. Otherwise, we appropriate those funds to these agencies for their work, in combating tobacco addiction. And I looked at some of the states where they've talked about, so in the Attorney General's letter, they talk about jurisdictions are approaching spending in various ways, including advisory councils, direct appropriation to agencies by the legislature, or legislative appropriation by category. So some of the states, they say, we appropriate 15% for drug treatment programs, 15% for prevention programs, different things, right? But, and then they let the other boards determine how to break that down. So there's different ways to handle it, and I just want everyone to be aware of that. So we are departing, so I asked for which states we had relied on when we drafted this. I looked at New York, which was one of the states cited. New York is very clear. The settlement fund, the opioid settlement fund, shall be available following appropriation by the legislature, shall only be expended on eligible expenditures as defined in another section for prevention, treatment, harm reduction, recovery service. But some states have retained their legislative authority over the funds. So because this is a big departure from that, I just wanted to kind of flesh that out a little bit more. And I know that I think we have the same purpose, right? And that is to get this money where it's very much needed and will make the biggest change in addiction on Guam. So I wanted to know, under current authority, you said under one settlement, you've kept the money at the AG's office and are using it pursuant to your authority under the Consumer Protection Act. Would that control these funds as well if we didn't pass this bill? Would you be able to keep the funds and control them at the Attorney General's office as you are doing with that other settlement?
Yes, and I believe even the settlement talks about if the legislature is not able to pass a legislation that sets up this structure that's being asked for in this bill, then it can resort to the executive authority, which would be the consumer protection laws, I guess, in this situation. But that doesn't mean that the legislature, if the legislature decided to make the appropriations directly, we recognize that as well. But if we don't have anything else, then we would have to fall to existing laws to try and use these funds as intended in the settlement agreement.
Yeah, there are some states where the governor is dictating the use and the advisory commissions by executive order and the legislature. So I'm glad that the legislature is doing this. I just think we need to keep in mind, how we're going to ensure against any, anything we can't we don't want to happen, of course. So let's go back to this section that I asked you about, 221606. It's on page 9 of the amended bill. It says the AG is designated as the single agency for Guam relative to bringing claims. And so I looked at some of the other jurisdictions, and in some of them, public health is the agency designated. In the tobacco settlement, public health was the agency designated as the single agency. It was also tasked with the responsibility of enforcement. Could you just please, I want it to be very clear on the record what we are agreeing to by agreeing to this. So if you could please be very explicit as to what authority we are granting to the Attorney Generals here.
My understanding is the purpose of this language is just so that it would be clear that we have what we call global peace in Guam. Unlike other states that have other subdivisions that have the authority to, on their own, to bring lawsuits against these companies, Guam doesn't have that. Our mayors, for example, don't have the authority to bring lawsuits against these companies. So that really is the purpose of this language, is just to indicate that there's global peace on Guam with regard to these cases that we're talking about this morning.
All right, would it bring other additional responsibilities to the AG's office in enforcement?
Enforcement of, I'm not sure I understand your question.
Well, for sure, the settlement agreement, for
Correct.
sure, in the tobacco settlement, as I said, they dictated public health, and then they granted them the ability to go and make sure that we are fighting, tobacco addiction, and they very explicitly gave them that mandate.
So so the responsibility would fall on our office to make sure that the expenditure of the funds are consistent with the terms of the settlement agreement. That would be our responsibility.
None other. I mean, no other, you're not going to take on public health's role, but we're taking this.
No, we wouldn't.
We're not designating public health, but we're going to leave them with their current jurisdiction.
Correct. We would work with them if we had to make sure that these programs these funds are used for the programs intended by the settlement.
All right, so this would allow you to decide for the rest of the government agencies whether they can bring a lawsuit or not against an opioid company or for any of these purposes.
Well, we currently do that with our agencies, and so this is consistent with our authority as provided in Guam law.
If we put this in the statute, would it be part of like a settlement so that we as Guam, for example, cannot dictate a lawsuit? I've seen some other statutes in the past. I think in the tobacco, the legislature authorized the AG to pursue that case. And would that preclude the legislature from authorizing the AG to proceed in any other case? Or to sue a certain company for some reason?
Well, as long as it's not as long as it's outside of what the settlement agreement provides already, what Mr. Perez had said already about being able to bring lawsuits, other lawsuits, as long as it doesn't pertain to the current lawsuit we have.
Right. This is very general. Okay.
Correct.
And so also, on page 4, subsection B, it says, all money, payment, or other things of value received on behalf of Guam. So the money that's being received is being received on behalf of Guam?
Yes, Speaker. That's correct.
All right, and can you interpret subsection C? It talks about the monies shall be used to supplement and not supplant. And then further on it goes, further, operating funds or baseline funding shall not be reduced due to monies expended from the fund. How is this going to tie the legislature's hands going forward? We've seen something like this in DOE promises in regards to receiving federal funds, that they can't reduce their, I can't remember how they describe it.
Yeah, that's correct. Most of our federal grants cannot be used to supplant existing funding sources. And so this is identical, this would be identical. So I wouldn't say it would impact any authority of the legislature in the sense that you can still appropriate, as you already do, revenues that come into Guam. This is just additional funds that shouldn't be used to replace what you normally appropriate to these agencies already.
All right, but in times like today or in our recent budget where we are struggling to find enough funds to fully fund these programs, we've been told by DOE we couldn't go any lower, even though we had no revenue, that we could not go lower. Is that going to prevent us from going lower if we have less revenue?
No, I don't think that it would do that. Yeah. As long as it doesn't supplant.
Yeah, so the oversight chair is reminding me, the term is maintenance of effort is what they describe it as in DOE. But that was a big impediment, I think, while we have
I think because of the matching. I think maybe what you're referring to might be the matching that Guam is supposed to, no?
No, they want us to have the exact same budget levels. And that's what I'm reading from here too.
No,
it's like,
we don't have that restriction here. I'm not really sure what exactly DOE is referring to, but I don't see that as applying in this situation, what you're describing.
Okay, well, I agree we want this to supplant and supplement existing efforts, but when we have decreased revenue, I just don't want our hands to be tied that way, yeah. But I guess this is why my next question goes to OFB, and that is, so the next section says that this is going to be, or subsection E says this is going to be administered by the Attorney General's office. This is the fund itself. And now in the Tobacco Settlement Fund, it was administered by DOA. They are the ones who administer all our funds pretty much, except for what we're finding out is at the AG's office in the settlement, some other settlement funds. So DOA administers the tobacco settlement funds, and I guess I'm just trying to find out, is there any reason why DOA cannot administer this? Because we're also going to be paying costs for administration. And if DOA is set up to do this already, I'm thinking it's an efficiency. But my question for OFB is this. In your letter, you say the proposed legislation is essentially administrative, but then you go on, however, identifies anticipation of initial funding through a non-tobacco settlement, which will fiscally impact government of Guam funds. And I'm wondering if you can just explain that.
Sure. So what we mean is this bill does not affect Office of Attorney General's funds because we appropriate general fund to OAG. And this bill does not use general fund. However, based on the council, it could potentially affect OAG's revenues, I believe, depending on how the council deems the use of the fund, depending on the expenditures, but we cannot determine the actual impact of it. It all depends on how the council uses it. But as for the bill, it doesn't use general funds, so it doesn't affect the way we budget OAG.
All right. And there's a cost allowed here without any cap. It just says reasonable. And this is on page 5, subsection A, under 221603. Monies in the fund may be expended to support reasonable costs. As we have seen with the Cancer Trust Fund, we think that the costs are exceeding, what is necessary to just administer these funds, especially, if we have an entire agency of the government set up to administer funds. And I would like your recommendation. I'd like to put a cap on that if, what reasonable costs are necessary. The Attorney General's office is is handling the litigation already. DOA is already handling, the trust funds, not just, in every other situation. So I guess we'll work with your office on that. Cap? Okay. And does the AG have any input on that?
I believe the settlement agreement actually limits how much of the proceeds can be used toward any administrative costs. So it's not a runaway reasonable, but I believe it is actually in the settlement, but I don't have the exact.
Yeah, I think if I read it correctly, it's like 50%, and there's no way I'm going to allow that. So I think, yeah, I'm looking at 5% at the most. If we keep it at the AGs, I'd like to put it to the DOA so that we can do that more efficiently and not have to incur additional costs. I want to know what other states included the judiciary and their advisory council. I can't find any.
Yeah, I don't know the answer to that question. And certainly if the body decides not to include the judiciary, that's of course the prerogative of the legislature.
All right, and is there any reason, so it says it's an advisory council. Do you believe this council is mandated to operate under the open government law?
That'll be your last question, Speaker. Ms. Titan?
I believe so. I mean, I'll have to, I guess, review how this is set up against the definition of open government law, but I believe the open government law is pretty broad, and it's only in situations when there's explicit language that says that the open government law doesn't apply, that potentially we would have to follow the open government law when this council meets.
Yeah, that's my biggest concern, is that we're delegating this authority away from the legislature to a council. We would like this council to get input from the public as much as possible and keep that process entirely open when we're talking about the use of funds. So I have some amendments planned for that as well. Mr. Chair, thank you.
All right. Thank you, Madam Speaker. Senator Clint, did you have any questions for the panel? Good. Thank you. Not being mean about it, but thank you, Senator Clint. My colleagues, we have completed the 2 rounds. All right? We will now dismiss the panel, and we will go into the 3rd round, which is basically for amendments and any comments to the bill. I'd like to thank the panel, Ms. Taino, Mr. Perez, Ms. Valencia. We will take a few-minute, I see signals, a 5-minute recess, and then we'll start back up with the 3rd round, and we're going to wrap it up with this bill. All right? Thank you. committee of the whole is called back to order. My colleagues, we are going to move to the third round. But I do have a motion from Senator Tello.
Sejus Masu, Mr. Chair. Mr. Chair, they're considering the new information that was provided to us today by your committee. We ask that if we can break during this time, take a break so that we can finish the amendments that are being proffered for this particular legislation, and ask that we recess until 2 o'clock.
All right, my colleagues, we will recess until 2 o'clock. I ask my colleagues, all your amendments by 2 o'clock. If it ain't in, it ain't going through. I'm going to rule it out of order. So you've got a couple of hours to put them all together. Senator Torres, do you have a comment, ma'am?
I would amend that, Mr. Chair, to maybe 1 o'clock, being that 2 o'clock is 3 hours away.
Okay, so
You can assume we can take an earlier lunch.
non-debatable motion, so we go to the 2? Okay, non-debatable motion, okay. One sounds good, but non-debatable?
Mr. Chair.
Yes.
You know, the reason why I chose 2 o'clock is because when we need to get these amendments, and now that you said that if these amendments don't get to the clerks on time, which could be not in our, power to make sure the clerks get it in on our time, that's going to take a little bit more time considering there's several amendments that are going through, number one. Two, then it gives us an hour only for us to grab something to eat and continue on for the rest of the day.
All right, we're on recess till 2 o'clock.
Thank you.